we are delighted that all of you are here with us. We have a small crowd in person, and we have some more of you on Zoom, and we're just really thrilled that you're here with us. And I'm going to let our Executive Director, Su-Ming Ye, introduce us and welcome everybody.
So good evening, everyone. Thank you all so much for joining us today. I'm the Executive Director of the Pennsylvania Institutional Law Project, and my name is Su-Ming Ye. I go by Su-Ming as my first name and she, her pronouns. So I just wanted to take a minute to thank everyone for joining, and really delighted to have you all here. As you may know, the Pennsylvania Institutional Law Project is a legal aid agency, and our goal is to ensure that everyone's constitutional and civil rights are met while they are incarcerated, and ultimately seeking the humane treatment of everyone who is incarcerated or detained in Pennsylvania. And we really couldn't do our work without people like you in the community. So we've been trying to do these community events where we can all gather, learn a little bit more about people's rights while they are incarcerated, and hopefully connect as well. So this is a hybrid event, which means we have an in-person audience, and then we also have people on Zoom virtually. And we did it this way because we wanted to have that in-person component, but also to make it accessible to all. So bear with us. Sometimes we might have some tech issues, but we will, continue along. So in particular, I wanted to thank Evangeline Wright and Terrell Mosley, who have really done the lion's share of work putting this together. And I also wanted to thank Sierra Shamer, who's helping out there today as well. So a couple logistical things. So the presentation and discussion will be done by Evangeline and Terrell. But if you have questions and you are on Zoom, you can put them in the chat, and then I will, at the end, hopefully we'll have time for questions, and I will direct them to the panelists. And if you are also on Zoom, what you can do, if you'd like, is to hide. There's a setting where you can just hide the non-speaker participants, if you'd like, and that way it'll focus on the. So again, if you have any questions, please feel free to put them in the chat, and hopefully we'll be able to get to them. And if you're in person, obviously, you can raise your hand at the end. So again, welcome. And with that, I'll turn it over to Terrell and Evangeline.
We are very, very happy that you're here with us, and we appreciate you giving up a summer evening to spend some time thinking about some of these issues. Terrell and I are going to be sharing some information with you today about how the past informs our current carceral system. Terrell's going to talk with you about that. He's also going to talk about what it actually means to be incarcerated, what that experience is like. I'm going to share some information with you about what laws protect incarcerated people. And both Terrell and I are going to talk about how PILP assists with reentry, some of the challenges that people face as they're coming out of incarceration, and some options they have to meet those challenges. So I am going to turn it over to Terrell to talk about the history of incarceration.
Thank you. So thanks everybody for joining us again. My name is Terrell Mosley. I am a community outreach coordinator as well as a legal assistant. And like she said, we're going to tie in a little bit of the history of the incarcerated state with the present times to kind of tie in where the inhumane treatment kind of started, the foundation of it. So the various influences on today's prison system are complex and multifaceted. The 13th Amendment to the United States Constitution is a legal provision that abolished slavery and voluntary servitude, except as a punishment for crime. It was passed by Congress on January 31st, 1865, and ratified by the required number of states on December 6, 1865. In 1865, the prison system in the United States was undergoing significant changes influenced by various social, economic, and political factors. The 13th Amendment, which abolished slavery, impacted the prison system. However, the amendment allowed involuntary servitude as a punishment for a crime, leading to the practices like convict leasing. Convict leasing, with the abolition of slavery, Southern states turned to convict leasing where prisoners, predominantly African Americans, were leased to private businesses. This system was harsh and exploitative, often described as slavery by another name. Today, prison labor continues to be a contentious issue, with incarcerated individuals, many of whom are African American, working for little or no pay. Prisons in 1865 varied from small local jails to larger state penitentiaries. Facilities were often overcrowded and unsanitary. Prison conditions were generally poor with inadequate food, clothing, and medical care. Punishments within prisons were harsh, including physical labor, solitary confinement, and corporal punishment. There were early reform movements aimed at improving conditions and focusing on rehabilitation. The Quakers and other reformers promoted the idea of penitentiaries where inmates could reflect on their crimes and reform their behavior. Pennsylvania and the Auburn systems were two influential models. The Pennsylvania system emphasized solitary confinement and penance, while the Auburn system focused on congregate work during the day and solitary confinement at night. Pennsylvania played a pivotal role in the evolution of the prison system in the United States, particularly through its influence on the development of the penitentiary model. This model emphasized rehabilitation over punishment and introduced new methods for managing inmates. Opening in 1829, Eastern State Penitentiary in Philadelphia was designed to implement the Pennsylvania system, also known as the separate system. It featured solitary confinement to encourage penance and reflection, which was a radical departure from the previous methods of incarceration that were largely punitive. The Pennsylvania system gained international recognition and influenced prison design and philosophy around the world. Many countries adopted elements of this system, reflecting its perceived effectiveness in promoting rehabilitation. Now, so the reason I say that to say this, so in 1865, you see how the inhumane treatment was kind of birthed. Now you fast forward to modern day today, and you see that not much has changed in the form of, the model of rehabilitation. We still use solitary confinement. We still use practices that are inhumane, like, for a punishment, they will strap you to a chair, 4-point strap you to a chair, if you're suicidal. And so these practices that were first initiated back in the 1800s are still being used today. I myself am formerly incarcerated, so I speak from a point of view of lived experience, and I can tell you firsthand that from the moment you go into prison, you're treated inhumanely. They strip search you. They force you to be naked in front of guards, both male and female, which is degrading both psychologically and physically.
Absolutely.
They ask you where you'd like your body shipped in the event that you die. And so this is when you first go in there. And so the treatment, like I said, isn't different from the past. So inadequate healthcare, medicines, some of the things that happen to you in prison, the best way that they feel as though they can treat you is by giving you a Tylenol. You break an arm, you go see the nurse, get a Tylenol. It's overcrowding, a lot of overcrowding. And in the event of overcrowding, you deal with lots of communicable diseases that spread faster. And for those individuals that they do put in solitary confinement, that's 22 hours in a cell by yourself. You get 1 hour out, and in that hour, you have to shower, use the phone, and then they call it rec time, which I don't understand how much time you can actually do with recreation with about 15 minutes to a half an hour. And so, as you can see, the confines, this is actually in the basement of what used to be the old Northumberland County Jail. So that unit right there, you see how close the bunks are. You have two people to a bunk. And so a lot of times when you're forced to be on a block, psychologically, you're surrounded by people a lot of times that have mental health issues. And so when you go in prisons and jails, you might go in there in sound mind, but 9 times out of 10, you're going to leave and you're going to suffer from PTSD because of the environment that you were exposed to. And so I say that to say this, that not only is it inhumane, they use it for rehabilitative purposes, but for those individuals who do get charged and not even necessarily convicted, if they can't afford their bail, then they also are forced to be incarcerated. And so you say, how's that work? You're supposed to be innocent until proven guilty, yet you're sitting in a population of incarcerated individuals and you have yet to be convicted of a crime. And so these are some of the obstacles that we face in our society with the prison systems of today. Thank you.
Thanks, Terrell, for that explanation. That provides a really good backdrop for what I want to talk with all of you about, which is we're going to do a really quick gallop through the legal rights of incarcerated people. And some of you are probably very familiar with these rights. For others of you, this might be a little newer. We're just going to touch on the basics of what PILP does and what rights are available to people. And I want to clarify here, we're talking about the civil legal rights of incarcerated people. PILP does not handle any criminal issues. This is solely civil issues. You're looking at right here a summary of a lot of the types of issues that PILP handles. We're going to talk in more detail, in particular, about medical care. I'm going to include mental health care under that category. We're going to talk a little bit about freedom from assault and sexual abuse. We're going to talk a little bit about clean, safe, humane living conditions. If we have time, we're going to talk about disability accommodations and some of the other issues that are listed here. This is a really brief outline of the laws that PILP typically uses to litigate our cases, and it's a pretty good summary of the laws that are available to incarcerated people in general to deal with those civil issues that affect them. United States Constitution, we're primarily litigating under the 8th, 14th, and First Amendment. As probably a lot of you know, that you're not going to see the phrase the right to medical care in the Constitution. That has been interpreted through case law, so we'll be talking a little bit about some of the cases that have interpreted that right into the Constitution. We also have some statutes listed there that are very useful for litigating rights for incarcerated people. We also do some work under Pennsylvania's state law. So a lot of PILP's work is done under the 8th Amendment. A lot of rights of incarcerated people are found in that 8th Amendment, and very specifically in that phrase, nor cruel and unusual punishments inflicted. That's going to apply to people that have been sentenced, people that are pretrial, are going to have a similar standard, but it's going to be under the 14th Amendment. It tends to be a little more lenient. Conditions of confinement is an issue that affects a lot of incarcerated people. This can be a difficult thing to litigate. In general, you have to look at all the conditions together. So for example, something like sanitation, a toilet that flushes, access to a shower that works, access to toilet paper, access to shampoo, to soap. If you are without those things for a couple of days as an isolated incident, it's a violation of your conditions of confinement. Nobody should be held in that way, but that's going to be a difficult issue to litigate. If you look at the totality of circumstances, if you are without those basic needs for a significant period of time, if the effect on you is fairly extreme, if several of these conditions that are listed there are affecting you, those start to become issues that potentially could be litigated. I would assume probably at some point, all of us are going to be reading articles this summer in the news about excessive heat in prisons. Particularly, we've all been talking about how hot it is this week. A lot of people are incarcerated in very old facilities that lack air conditioning. And increasingly, that's becoming an issue in the summer. Winter, of course, cold is an issue. Infestations, often there's cockroaches, rats, mice. I don't know if you could speak to this at all, Terrell.
Oh yeah, it's pretty bad. Yeah, all the above. In the summertime, it's brutally hot. You get it like one big fan for the whole block. You hardly get any circulation of regular air. So yeah, like it's like a breeding ground for bacteria and sickness. Yeah.
Another legal issue that PILP tends to see a lot of that significantly impacts people who are incarcerated is safety from violence. That really falls into two categories: excessive force, sexual abuse. What we're really talking about there are issues between correctional officers and incarcerated people. When we're using the phrase failure to protect, we're talking about issues between incarcerated people. And both of those, unfortunately, can be problematic for people that are imprisoned. Excessive force, the standard for people who are post-sentence, who have been sentenced and convicted, that's going to be under the 8th Amendment. And really the phrase there is whether the force was applied in a good faith effort to maintain or restore discipline, or maliciously and sadistically to cause harm. And I want to pause for a second on the phrase maliciously and sadistically, because that is a high standard. In order to successfully litigate one of these cases, you really need to be able to show malicious and sadistic intent on the part of the correctional officer. Pre-trial, the standard is a little,
What would be examples of that? Like bruises, actual bruises, in order for the
so
individual to prove that?
that's a really good question, Terrell. And we all know that in a carceral setting, correctional officers are going to say that somebody was not following orders. They're going to say somebody was not following the rules, and that it was necessary for them to take steps to correct that. And correctional officers could use pepper spray in situations like that. They could take somebody down to the ground. They could put restraints on. And if somebody is injured while those things are happening, unless you can show that there was malicious and sadistic intent, it's going to be really difficult to litigate that case. So if somebody was already restrained and you pepper sprayed them, there is no correctional goal that can be served by that because they are already restrained. That might get you to malicious and sadistic intent. But I say might. I mean, it really depends on the circumstances. So the standard for somebody who is pretrial, who's not been sentenced yet, is a little bit easier to meet. And really the rubric there is, was the force objectively unreasonable? A little bit of an easier standard. Failure to protect. Again, that is where we're looking at issues between incarcerated people. Farmer v. Brennan is the Supreme Court case there. That's really the foundational case in this area. And the standard there is whether a prison official knows of and disregards an excessive risk to inmate health or safety. And I want to really focus in on that phrase, knows of and disregards. The phrase knows of. Often to successfully litigate these cases, you're looking at some type of notice. And ideally, you're looking at notice in writing. Because if you give verbal notice to a correctional officer that you are feeling unsafe, it can be difficult to prove that you gave that notice, that the correctional officer understood what you were saying. So if you have a situation where a cellmate, you feel endangered by them, and that cellmate then attacks you, that looks like a failure to protect. The prison officials put you in the same cell with that person. But if you had not previously given notice, that could be difficult to successfully litigate. On the other hand, if you provide written notice, if you say, I feel unsafe, this person has said this to me, this is what's going on here, and you've given that in writing, and then you are assaulted, that could lead to successful litigation.
So basically you need a paper trail.
Paper trail is always good. I'm not going to say that you couldn't successfully litigate a case without that, but it would be exponentially more difficult. Yeah. So medical care is one of the really big issues that we handle for people. This is something that we get a tremendous amount of letters about, and is always been a big issue. And as prison population ages, is becoming ever greater of an issue. So we've got a list here of the types of issues that we tend to see. I think PILP has probably litigated in all of these categories. The basics of prison medical care usually starts when you enter the carceral system. You're going to get an intake assessment. It's going to be a basic physical. They're going to try to identify any preconditions that you have, conditions coming in, what care you might have been receiving on the outside, if you have chronic conditions, if you're diabetic, if you have a mental health condition that requires management through medication, if you are in cancer treatment. These are things they're going to try to identify at the point you enter the system and try to give you continuity of care. Now, the care you're going to receive is not the same care you might have gotten on the outside. So if you were getting one medication for your diabetes on the outside, you're going to get medication on the inside, but it might not be the same medication that you were getting. It might be a medication that, for whatever reason, they feel is going to meet their goals better, might or might not work the same for you. Same thing with hypertension type drugs, opioid use disorder. You're not going to get that same type of care. Once you're in the system, if a healthcare issue arises, let's say you sprain your ankle, you have a rash, the types of issues that you might go to an urgent care facility for on the outside, you have the option to seek medical care in the carceral system. Usually you're going to do that by submitting a sick call slip. But just as on the outside, when you seek health care, typically you pay a copay. You're also going to pay a copay on the inside for sick calls. I believe in the state correctional system, your copay right now is going to be $5, which may not sound like a lot. Right now, that's probably equivalent to a Starbucks cup of coffee for us. But if you are incarcerated, that $5 could represent a significant portion of your resources. If you're in the state carceral system and you have a prison job there, your average wages you may be making as little as 28 cents an hour. Your wages may go up to as much as 50 cents an hour. Certain jobs, not the majority of jobs, you might be getting 60, maybe 70 cents an hour if you're lucky. But if that is your hourly wage and you are paying for additional food from that, you're paying for phone calls, you're paying for access to a tablet, $5 is going to represent a very significant portion of your assets. You may also need access to outside appointments. You're going to get those appointments potentially, but you are probably going to wait a very long time for them, and you're not going to choose which outside doctor is going to see you. So if you need surgery, if you need something that cannot be provided within the carceral system, you're going to go outside and you might wait a long time for that. Foundational case there is Estelle versus Gamble. Standard is a prisoner must allege acts or omissions sufficiently harmful to evidence deliberate indifference to serious medical needs. That is a very high standard. That requires more than medical malpractice. Just going to skip through that. It is a higher standard than what you would need to prove under Pennsylvania law. So malpractice law applies to incarcerated people also. They can bring a malpractice suit under state law, but that malpractice suit is probably going to require the input of an expert. In order to file a malpractice suit, you're going to need to file a certificate, and then a certificate from an outside expert stating that your issue is legitimate. And then you're probably, in order to win that case, going to need expert testimony as well. Medical cases tend to fall under two general categories, whether it's a problematic rule, problematic practice. Problematic rules could include things like one good eye, which PILP successfully litigated in the past. State prison system used to have a policy that they would only provide cataract surgery for one eye. If you had cataracts in both eyes, you got one eye done, and then you were considered, your vision was adequate. PILP successfully challenged that. They now do provide cataract surgery in both eyes. PILP also successfully challenged access to hepatitis C treatment, and that treatment is now widely available within the state prison system. PILP is currently litigating quite a few cases for opioid use disorder. Problematic delivery of care is the other category where you tend to see issues. Chronic care issues like diabetes care, mental health care, things like specialist appointments and surgeries, those can be very difficult to get ongoing care that's going to meet your needs. So what that deliberate indifference standard basically boils down to is that you're going to get medical care, but it's going to be medical care without choices. You will get basic care, but it may or may not meet your needs. Disability accommodations sometimes go hand in hand with the medical care issues. People who are incarcerated have the right to have accommodations for their disabilities. Those tend to be litigated under the Americans with Disabilities Act or the Rehabilitation Act, depending on who you're litigating against. Even if you're incarcerated, the prison, the jail, the detention center incarcerating you still has a duty to provide reasonable accommodation for your disabilities. We're going to touch just really briefly on some of the other rights that incarcerated people have. Under the First Amendment, you have the right to observe your religion. That can also be litigated under the Religious Land Use or Religious Freedom or Restoration Act. The first one is for state and county prisons. Second one is for federal prisons. Under the First Amendment, you also have the right to be free from retaliation when you're exercising a constitutional right. So for example, if you file a grievance and you have consequences for filing that grievance.
Put you in the hole.
Yeah, as Terrell said, they put you in the hole. Maybe they mess with your meals. Maybe you
Take away your privileges, no yard time.
Yeah.
Yeah.
Yeah, as probably as obvious from what Terrell is saying, this happens, right?
Yeah, often.
Can be a difficult thing to litigate, but you do have the right under the First Amendment to be free from retaliation. Freedom of the press, access to publications, also access to the courts, which you're going to see playing out in the context of access to your legal mail, the right to communicate with your lawyer, legal visits, all fall under the First Amendment. And on that note, I'm going to turn this back over to Terrell to talk a little bit about his work with reentry into society.
So like re-entering society is a difficult task. Some of the roles that I do here is I go talk to individuals that are incarcerated, and I try to help them come up with a plan or set some goals as far as what they're going to do once they re-enter society. So they consider that to be called reentry. And reentry, a lot of depending on who you talk to, people might say reentry starts, when you're almost getting out of jail. But for me, reentry starts when a person first gets incarcerated. Because the minute you step foot in jail or prison, you have to come up with a plan. You have to understand like you're there, and you have to start figuring out what you're going to do once you return home, because eventually you're going to get out. Most people that are in prison and jails, one day they are going to get out. And when they do get out, you want to make sure they're equipped with what's needed to prevent them from going back. So some of the issues that arise with some of the individuals that I talk to, first things first is home. Where they're going to go to, where they're going to go when they get out, their network, who they're going to be around. One of the major things is a lot of times people entering back into society are on supervision. So if they're on probation or parole, the big thing there is you have to still report to your probation or parole officer. So knowing that they have their own set of stipulations that they're going to put on a person once they come home, and then you have to abide by those stipulations. A lot of times, like I try to really inform individuals of is that your mental health is first and foremost the most important thing when you get home from prison and jail. If your mental health isn't intact, then 9 times out of 10 you're going to go back. And so you have to make it a priority, because being in jail and prison in and of itself is psychologically dehumanizing. And so it takes a toll on you psychologically more so than physically. And so you have to reacclimate yourself back in society. Just walking down the street is going to feel funny. Driving in a car is going to feel funny. Communicating with people, going to sleep. I know for the longest time, when I came home, I couldn't even sleep with the light off because the light stays on in jail. And there's so much noise that goes on all the time on the block that you have to listen. You almost have to be acclimated when you get home to the same things that you had inside. So, you're home, and a lot of times job, is a major thing. If you had substance use disorder when you went in, more than likely you didn't really get any kind of help or treatment inside. So you're going to have to worry about that when you get out. There's so much temptation that's going to be thrown at you. And there's going to be so many things that are thrown at you once you get home that it's best to come up with a plan. And so that's why I really put emphasis on meeting with individuals, mentoring them, sharing my story with them, letting them know that it is possible to come home and be productive. And so, focusing on those areas with individuals is key, because there's so many barriers, barriers to employment, transportation barriers. And where we live, there's no public transportation. So that's a huge issue in this area. Is how they're going to get around, because a lot of people's license gets suspended. So when they come home, they have to arrange all these things. And it's also good to have like a stable network of support on the streets. Sometimes people don't have that because they burned bridges before they went in. And so when they come home, they're left to their own vices, they're alone. And so when you're in jail and prison, even though you might be surrounded by a lot of individuals, you still feel a sense of isolation. So that's where the PTSD comes in. Mentally, it's like going to war. So when you come home, it's best to have some kind of structure plan as to what you're going to do once you do get out. And so we help out in those areas as far as the barriers to employment. We help people if they need to get IDs, set people up with getting IDs, social security cards. One of the main things that we deal with as far as reentry.
Yeah. So some of the other things we deal with in terms of reentry, access to public benefits. So medical assistance, Medicare, Medicaid. Medicare is primarily for those over the age of 65 or those with long-term disabilities. Medicaid is offered to those of all ages. There are income limitations, sometimes asset limitations for that. I think the state system may help people apply for that before they reenter society, but that is also something that PELP can give advice about and can discuss with people as they're looking at how they go about applying for those benefits. Also, Social Security benefits for those who need, and this would mainly apply to those who have long-term disability, but long-term disability can include some of those mental health issues that you were talking about, Terrell. Social Security disability income is tied to your earning history and requires that you've earned enough money over your lifetime and that you've earned enough money recently to qualify for it. And the amount of that benefit is linked to that earning history. Supplemental security income does not require an employment history. It is linked to your current income and your disability. So if you have a long-term disability and lack the earning history to qualify for Social Security disability, supplemental security income can be an option. I think in the state of Pennsylvania, the maximum benefit for that right now is about $943. So it's not a lot of income, but that is something we're able to advise people about and assist them with getting that started if that's something that they need. Settlements, if somebody does successfully litigate an issue against a prison or a jail and gets a monetary settlement, and they are already on the outside by the time that settlement comes through, because sometimes it can take a while, and are receiving public benefits, that settlement can have an effect on those public benefits. So that's also something that we are able to assist with. Like Terrell said, we also can provide some help, sometimes cutting through some of the red tape in terms of barriers to employment, in terms of getting, people may come out of incarceration without that driver's license, without that Social Security card, which is virtually impossible to get employment without that type of documentation. So we can assist with that. On a more long-term basis, the existence of a criminal record can be a serious barrier to employment. Employers look at these things, and it can be extremely difficult to get a job, as I'm sure you encounter when you're counseling people too.
Absolutely.
So there are some options for addressing that. Some of you may have seen information about Clean Slate in the news recently, because that has recently been expanded. I'm not going to go into a lot of detail about that because there are people that can speak to that better than I can. PILP does not do a lot of work with that, but that is definitely something to be aware of. There is quite a bit of excellent information available at the website that I've listed there. I will also flag the fact that North Penn Legal Services, which provides free legal services to low-income people in the northeastern zone of Pennsylvania, is going to be doing a clinic on June 26th. I think it's at noon in Sunbury, to assist people with understanding Clean Slate and working through that. I think they're going to address both Clean Slate and expungements. One thing to know about Clean Slate is that it seals your record, which means that record, if you have, and this does not work for all criminal histories, there are some felony convictions can be sealed under Clean Slate, but there's a waiting period of 10 years, I believe. Most misdemeanor convictions can be sealed after 7 years. All summary convictions can be sealed after 5 years, I believe. The great thing about Clean Slate is that if you qualify, it's automatic. You do not have to file anything to make that happen. An expungement means that your criminal record is completely erased, which is more beneficial than having your criminal record sealed, because although a sealed record is not available to the general public, it can be available under certain circumstances to law enforcement. Mm-hmm. If your record is expunged, it is completely erased, but an expungement requires that you affirmatively file something with the Court of Common Pleas. A lot of legal aid programs, more traditional legal aid programs around the state, provide assistance with expungements. That's also something that PELP can advise people about. And again, not all criminal records can be expunged, but it is certainly something worth looking into. It's not going to be an immediate solution when you are first coming out of incarceration. The final option for addressing a criminal record is a pardon. And that does not move through the court system. That moves through the Governor's Board of Pardons. That's basically an administrative process. You need to file with the Governor's Board of Pardons. You file an application. I believe right now it is taking about 4 years from start to finish for an application to move through that system. I think it takes about 2.5 years to know whether you're even going to get a hearing on whether you can get a pardon. So it is by no means a quick process. It is also something you do not want to apply for a pardon until a significant amount of time has elapsed between when you move out of incarceration, when your last conviction was, and when you apply for the pardon. How long needs to elapse is really, it's discretionary, but I would look to the severity of the crime to determine how long that period should be. Some of the factors that the Board of Pardons will look at is how long a person has been crime-free. They will look at how successful the rehabilitation has been. What can you point to say, I am rehabilitated now? You're also going to need to point to a specific need for clemency. You're going to need to point to a factor in your life that will be significantly changed by receiving a pardon. And that might be something like, if I can get a pardon, maybe I can become a nurse. Maybe I can go back to providing something that requires a professional license that I can't do with this criminal history. The other thing you need to be aware of with a pardon is that Board of Pardons will look at victim impact. They have to notify your victim or the next of kin of that victim, and that victim has a right to be at the pardon hearing and to have their viewpoint heard. So that can be another factor. Pardons are excellent when they're granted, but not all pardons are granted. It's a relatively small percentage. So those are basically your options for clearing the criminal history. And I don't know, Terrell, if you want to talk at all toward some of the effects you see of having a criminal history.
Yeah, I mean, it's tough, when you have a history, especially when it comes to employment. You try to get a job and, it looks like promising that you're going to get the job, and then they run your record and they'll say, well, we're sorry to inform you, but we can't hire you. That happened to me numerous times. Jobs that I really wanted, that I look forward to. I mean, and so when you don't get that job, it's defeating. For some that may have happened 10, 15 years ago, and they still won't give you a shot because of that. And so not only do you not get the job, so it's hard to provide, but also psychologically it sets you back, because it's like, okay, well, if you did do it, you did the time, you served your punishment. And so when you come back in society, you think, well, now you can move on with your life. Well, that's not the case a lot of the times for a lot of people that have records. And that's why they're trying to push this clean slate thing, because in society, it's like people try to judge you off of your record. They might not know you, but they see that you have these charges, and they judge you based upon that. So it's tough. It's tough when you have a record.
For sure. So Tulp is very happy always to talk to people about some of those reentry issues, provide advice about that. Like I said, a lot of that information is online as well. And on that note, we're going to open this up to questions. So I don't know if there are questions online or.
There was just one question relating to someone being interested in disability accommodations. So I thought maybe you could talk a little bit more about that.
Yeah, just generally discuss disability accommodations.
Yeah, what you've seen and how people. Yeah, and then how people. It was a general question or comment, but maybe walking through, like, how do you request one, and that might be helpful to explain.
So that's an excellent question. The first step in seeking a disability accommodation is to make that need known. In the state and federal department. Well, State Department of Corrections, there's a specific form that you can use to request disability accommodations. You need to, in that form, you're going to fill out what your disability is, how it is impacting you, how it affects your daily living, your activities of daily living, and what accommodations would allow you to engage in those activities. So for example, if you have a physical disability, let's say a mobility impairment, and you're having difficulty walking, you might explain what that difficulty is. You might say that it is difficult for me to get onto my top bunk. It is difficult for me to walk to the dining hall. It is difficult for me to get out to recreation. And then you're going to suggest some accommodations that might address that. Accommodations might be, I need a wheelchair. I need a walker. I need a code that would allow me to always have the bottom bunk. Maybe I need assistance getting places. You explain all of those, you submit that, and then you should get a response to that accommodation request. And if your accommodation is turned down, that's a good time to maybe reach out to PILP and to see if there's anything we can do to assist you with that. Disability accommodations are also not limited to physical disabilities. So for example, opioid use disorder can fall under the Americans with Disabilities Act. So if you are incarcerated and you've been receiving treatment for opioid use disorder, on the outside, you're receiving medically assisted treatment, and you need that treatment to continue when you are incarcerated and you're not receiving that treatment, you can submit a disability accommodation request form, and the accommodation that you request might be access to Suboxone, access to the medication that you were receiving on the outside. Certainly accommodations for mental health care, can also request those.
There was a follow-up question to that about also not just physical disabilities, but also people who are autistic or have intellectual disabilities.
Yeah, absolutely. Those should also fall under the Americans with Disabilities Act, the Rehabilitation Act. And in the same way, you're going to be requesting those accommodations. So for example, if you have an intellectual disability, you're going to want to explain that, to request an accommodation that might include, in that case, that might include an aide to help you fill out paperwork, depending on the intellectual disability. Obviously, depending on the severity of the disability, filling out that accommodations request form might be a barrier already. And that also would be something that would be a really good idea to contact PILP about. Yeah, that's what I want to say about that.
I don't see other questions in the chat. Did anyone else have any questions they wanted to ask?
I do not think we have any in-person questions here. Oh, Sierra has flagged another question in the chat. I don't know if you want to read it to me, Sierra.
Yeah, and the question is, has the issue lack of sickle cell treatment been brought to our attention? There's a new drug that is supposed to help with that.
So that's a really good question that I can't actually speak to because I only see a small fraction of the intake that comes in. So it is possible we've gotten information about somebody seeking that, but I'm not aware of it. And I don't know that our central Pennsylvania intake staff is aware of that either. Any other questions that anybody wanted to bring up?
Yeah, there's a question. So thanks for that question on the sickle cell treatment, which I know has come across the desk of PILP in the past, and I know that can be very difficult, both as a medical issue and in terms of a accommodation issue. So we'll keep an eye out. Another question is, people with disabilities are bullied by other incarcerated people. What is the responsibility of the facility to prevent that, especially if the problem has been made known over time?
That's an interesting question. And I think it really would go to the type of behavior that was occurring, the severity, the frequency, and how that was affecting somebody. So if it was affecting activities of daily living, so for example, if somebody was being bullied such that they were not able to go to meals, such that they were not able to go out to recreational time, and that bullying was clearly linked to their disability, accommodations could be requested for that, and accommodations could include, maybe a separation from the situation that was leading to that. It could include, depending on the circumstances, maybe access to food in a different way. It would be very, very situationally dependent, but it is certainly something that I think you could make a case would fall under the Disability Act.
And I'll touch on that a little bit too. It's sad to say, but in prisons and jails, it's like they have their own culture and their own structure. So if a person has a disability while they're incarcerated, to the general population, that might be looked upon as being weak. And unfortunately, people prey on the weak in prisons. So what I would recommend do is, put a grievance in and make sure they document it. Everything that's happening, they document it, they write it down. Even if it's the littlest thing, they write it down, and then try to make sure that they have witnesses and put the witnesses down on a statement as well. And then sometimes even in jails and prisons, the power structure, they laugh at people that put in grievances for things that are questionable, like bullying and things like that. So you might have to grieve to a higher up. You might have to put in a slip to somebody higher up or contact somebody out in the streets to try to rectify the situation from outside the jails and the prisons.
Okay, another question. Is there something that can be done to secure standards of preventative care that echoes what is done in the community?
I would love that. I would really, really love that. So preventive care. Yes, it would save the community. It would save prisons a lot of money if you had adequate preventive care. Hypothetically, that right exists. You're supposed to receive preventive dental care within the state prison system. You're supposed to receive, if you're female, you're supposed to receive pap smears on a regular basis. In practice, that sometimes happens and it sometimes does not. Those are difficult issues to litigate because to show causation of harm, causation of damages can be an extremely difficult thing. Issues that have a widespread, wide impact that impact people in small ways that add up to bigger problems, just by their very nature are very, very difficult to litigate. I'm not going to say it's impossible, but those are, I think, a good example of why that's difficult would be to look at diabetic care, because if you can manage somebody on their insulin, that's great preventive care. If you can prevent their blood sugar from shooting up, they're going to have better outcomes. But demonstrating the causation of harm between, let's say, somebody does not receive their insulin on a regular schedule. Somebody does not receive it with their meals. They miss a few days of insulin. They don't get the meals they need. Maybe they get too much starch. Maybe they're not getting enough protein. All of those things would fall under preventive care. But being able to say all these small little pieces added up to this person's blood sugar being out of control and added up to them, for example, having to have an amputation, is an extraordinarily difficult thing to prove. And that really is the challenge with litigating that type of issue.
Would those type of issues that you were talking about, preventive care, where possibly they may not reach a level of litigation, but where advocacy could come into play, where trying to get through to people that, look, you might spend a little money here, but you're saving a lot of taxpayers' money down the road, and try to change the system that way, as opposed where litigation it may be very difficult.
So we just had an excellent comment here in the in-person space. Dave pointed out that, sometimes advocacy is a better tool for that, short of litigation, bringing public attention to this, advocating outside of the legal system may be a better avenue for that. And I think you're 100% right. And that's wonderful. It does fall somewhat outside what PELP can do, but we love that there's a community of people outside of PELP who can engage in that kind of advocacy. And we are very, very grateful for the people that do engage in that type of advocacy.
Well, even forms of just sending advocacy letters, right? and bringing attention to it and awareness. Like sometimes that puts a fire under the prison
Yes.
systems as well.
Yeah, and PILP does engage in some advocacy letters, but those advocacy letters have more tooth to it when you can say, we will possibly litigate this issue. Otherwise, we're in the position of just saying, hey, we'd really like you to do this, which has value, but may not always get listened to. So a community of people saying this is an issue of concern to us is a really wonderful thing.
All right, here's another question. How can we get outdoor rec for our county jails? And I don't know if the two of you know the response to that, if I can fill in if needed.
So I'm going to just speak a little to that, and I might let Su-Ming or Terrell, if you have thoughts on this, address it as well. But one issue, anytime you are dealing with county jails, is that you are dealing with a constellation of different administrations. Unlike the federal system, where you have a centralized system that's administering several prisons, or the Pennsylvania state system, where again, you have a central system that's administering several prisons. County jail system is specific to each county. You know, some county jails may cover more than one county, but you're dealing with several different administrations, each with their own goals, each with their own administrative system to make change happen. And that right there is a significant difficulty. I don't know if you wanted to add anything to that.
That's above my pay grade, but I do believe that recreation should be standard and should be allowed to people that are incarcerated. I don't know if that's like a right, like a constitutional right in the jails.
Conditions.
Yeah.
Yeah, so the issue of recreation in county jails is actually not a constitutional, it possibly could be a constitutional right. We've looked into it a little bit, and that's a little tough. It is actually a state law right. So people are entitled to 2 hours of outdoor recreation under state law. The challenge with it being a state law is that in order to enforce it, you have to bring a writ of mandamus in the Commonwealth Court of Pennsylvania. So I am aware, for example, Center County Jail, it's not set up, the way they built it, there's no outdoor rec, which I think is completely wrong. They're not obeying the law. So all their rec is indoors. The challenge is that, you know, because it's a state law as opposed to a federal law, you would have to challenge it through some other litigation means. Occasionally we've had, at one point we did litigate an issue of someone in the State Department of Corrections not getting outdoor rec, and I think he himself, the individual, filed on his own because the Department of Corrections kept giving excuses due to inclement weather about not giving outdoor rec. And that individual was successful in getting further clarity and pressuring the DOC. But that's essentially where that is right now. So, and you yourself people may know of other places where that's a problem. So I think we have 4 minutes left. I'm just gonna maybe skip around. There are a few questions about, like, can I bring a lawsuit? So for example, is there a way to put a lawsuit in for being denied medication or prescriptions that they were on for years prior to their incarceration? If so, how do I go about doing that?
So any type of lawsuit with medical care is going to be complicated. If I'm understanding the situation correctly, you're asking, can you litigate the issue of somebody having a certain medication on the outside for several years and then being incarcerated and not receiving that medication? And that's really going to go to the specific details. I mean, without knowing, there's no right to have that specific medication continued. So again, I'm going to return to the diabetic example. If you were receiving a specific medication to manage your diabetes on the outside, and you become incarcerated and you are receiving some medication, and that medication is within a medical standard. It meets the standard of care. It does not mean it is an acceptable medication to treat diabetes, even if you don't feel it's as effective, even if it's not working as well for you as the specific medication you had on the outside. Litigating that issue is going to be incredibly difficult because that standard of deliberate indifference is so difficult to meet. And as long as you're meeting that standard of care, that's going to be really, really difficult. On the other hand, let's say the medication you were receiving on the outside was an immunotherapy drug for cancer, and you become incarcerated and you're receiving no medication at all to manage your cancer, which would be unusual and is probably a more extreme example than the questioner may be thinking of, but we'll go ahead and use that example. That probably could meet the standard of deliberate indifference, depending on the surrounding details. Because if you are dependent on that immunotherapy drug and you are receiving no medical treatment to meet that need whatsoever, and it is having a significant effect on your health, that is going to become something that does start to look like deliberate indifference.
And just a couple reminders on filing a lawsuit is, one, if you're currently incarcerated, you really have to file a grievance in order for you to bring that lawsuit. Otherwise, the Prison Litigation and Reform Act will prevent you. If you are released, then you do not have to have done that. But if you're released, just be aware that typically there's a 2 years, what's called a statute of limitations. You have to file that lawsuit within 2 years of when that happened. There's some other rules governing it, but just keep that in mind. So if it was like 10 years ago, you likely will not be successful in bringing a lawsuit. It'll get kicked out for being too late. All right. Let's see. It's 7:29. It was just one question here. Can I file a lawsuit against the prison or DOC for having my husband and his cellie in their cell for 4 days with a broken toilet?
So that, if you recall, as I was galloping through the legal rights, we talked a little bit about conditions of confinement. 4 days without a broken toilet is inhumane. It should never happen. Nobody should ever be subjected to that. Whether you could successfully litigate that issue, I think it would be very difficult to convince a judge that you should recover damages for that situation. Because I think a judge is going to look at 4 days and say that is just not a long enough period of time to arise to that standard. Because again, that is a very, very, very difficult standard to meet. That said, that type of issue should never occur.
Sometimes it depends on what your damage is then or to.
Yeah.
Is it?
Yeah. Well,
feasible?
and that's a very good point. I mean,
that's.
yeah, if you can say I was without a toilet and I became very, very, very ill, and it had this long-term impact on me that has changed my life. Absolutely. I think that could get you to a potentially successful lawsuit, but you would need to point to that impact in order to make that happen, I think, successfully.
Can I just jump in and just thank everyone for all your questions, for participating. I know a lot of people made requests in the chat. So for either the copy of the PowerPoint presentation or a link to the recording. So feel free to do that. You can also email us at info@pilp.org. If afterwards you're like, I forgot to say that and I still want a copy. So just go ahead and email us there. And then also just as a reminder, we also have a lot of information and resources on our website, www.pilp.org, and as well as on our social media.
And I will just add my thanks to all of you for being here. We really appreciate you taking the time to spend this time with us and listen to what we have to say.
Yeah, I second that. Thank you. And hope you guys have a good rest of your evening.